Hello there. I'm Steve Singer, Chair of the UU Endowment Committee, and welcome to the second of a two-part seminar on charitable giving. Last week, we heard presentations from Gary Belkin and June Oliver on how you as U.S. and Canadian citizens can maximize the size of your estate through charitable giving and thus provide more for your loved ones while benefiting the causes you care about. This week, we will hear from Ian Clement, a San Miguel attorney specializing in will preparation and estate planning. Both seminars will be available on the UU Fellowship's YouTube channel, and will have a link from the UU website endowment tab as well. During Ian's presentation, which is in the form of a series of questions and answers, you will have the opportunity to ask your own questions. Just click on the chat box and type your question. Please understand, though, that the purpose of this session is to present generalized information. We are precluded from giving legal advice. At the end of the presentation, we'll put up on the screen Ian's contact information so you can engage him directly. And now I give you Ian. Take it away.
All right, good afternoon. My name's Ian Clement, attorney at law here in San Miguel de Allende, Guanajuato. I'm excited to bring you some questions and answers. I have quite a few friends and clients in the UU, so those of you who don't know me, I'm very excited to present some information for you. And I hope that once we're through with this, you'll come up with some questions that relate to items that people will be involved in and interested in knowing about. So I hope that this can be as interactive as possible. And I really hope that the information that I provide is useful for everybody and begins to get the ball rolling if people have questions or doubts about their estate in Mexico. Okay, so we have 14 questions. And question number one is, who needs a will in Mexico? Well, the answer to that is two sorts of individuals need wills in Mexico. One would be somebody who owns property in Mexico, which is a definitive reason to have a will in Mexico. If you do own property and are not somebody who's made a will for Mexico yet, then your property would fall into probate. You would have a huge problem. So I really suggest that if you own a property or are going to buy one in the near future, as a insurance to make sure that everything is fluid if you were to die unexpectedly, definitely have a will made for Mexico. Okay. The other reason that you would make a will in Mexico is if you have movable belongings that really matter to you and you want them to be itemized and officially recorded as your belongings in Mexico. Really important that you don't pass away and have a vague situation with what all of your assets are in Mexico. Typically, if somebody owns their house and those items are not specifically detailed, there's not a problem. But where I have seen problems with clients are when they rent properties, okay, and you have lots of property that's inside of a rental house or apartment, and it's very hard to say what's what and who's whose. So you want to make sure that your landlord understands what's yours, have a list of items. And if there are conflicts there, you want to be aware of that because you can have a situation that's very sticky. And you don't want your heirs to have to go through a fight with a landlord or landlady who's become difficult when it comes to releasing your property. Okay. So those would be the two reasons. And most people who live here own a house and own movable property. So you could have a hybrid of both of those reasons being the catalyst to have the will. Okay. So that's number one. Number two is, why is September Will Month in Mexico? People ask me this all the time, and it's kind of funny to people who are from Mexico. Perfectly understandable. Why would it be September? I'm not exactly sure why they chose September, but they chose September as the will to incentivize individuals to create a will for Mexico. Notaries have to charge half price during that month for the service, and people are lined up to get that done. So it's a very good incentive by the government. And so it also is something that foreigners can take advantage of. and pay a reduced rate for their will. So there's no reason to not make a will for Mexico. Number 3, how can you leave inheritance? Who can you leave inheritance to through your Mexican will? You can leave inheritance to 3 basic groups, right? The first group would be individuals. So family, friends, people who you care for, who you want to leave money or property to, okay? You can leave property to people in the United States. You can leave property to people in Mexico or anywhere in the world, as long as the details are clear and the person is identified correctly. There is no problem with that. And that's the most common type of inheritance that's left, is to an individual. Number 2 would be to an organization. And the UU is a perfect example of an organization that is legitimately able to accept inheritance from people who've died in Mexico. And we can go into that in another question that's a bit down the line. But the simple answer is, as long as the details and the information on the institution is correctly provided in the will, then there's perfect fluidity in that inheritance by the organization, by the nonprofit organization. Okay, that's an important part to be aware of. That the organization that you leave your inheritance to, as long as you want the benefits of what we're going to go over in the following chapter, is that it be a not-for-profit organization, or in Mexico, en asociación sin fines de lucro, okay? Number 4, do you need a will for the United States / Canada and Mexico, or wherever it is that you're from? So if you're a foreigner and you have assets in another country, which is your homeland, or another country where you've established property ownership, then you're going to need to have wills for each different jurisdiction. This is very important, and a lot of people don't realize this. If you have property in Mexico, you absolutely need to have documents to protect and firewall that property within the jurisdiction of Mexico, okay? So what would that be? That would be a will made for the state of Guanajuato, which would speak to what the trajectory of all your assets upon your passing away would be. So if you have assets in the United States or Canada, then you also have to have a will for that country. I've had people come to my office many times and say that their U.S. attorney spoke to them and told them that it was a good idea to have Mexico written into their U.S. will. This is not the case. This is absolutely not the case, and you don't want this overlapping. So you want to make sure that the document that's made in Mexico only speaks to Mexican property. That's not going to be a problem, because a Mexican notary or Mexican attorney is not going to have you write about a different country's assets. But I've seen it in the United States, not Canada, but I've seen it with U.S. attorneys, where because they don't work in very many cases of an international nature, they think that it's perfectly kosher to move language into the U.S. will that speaks about what happens to the property in San Miguel, but it does not have bearing within the legal system. And if it were in that document and there were no Mexican will, you would still go into a probate intestate situation. And we'll go into that a bit more in another question as far as fleshing out the details of that. But you really want to make sure that if you have property beyond just Mexico, you need a will for that country. And that basically simplifies everything. And one more thing, you can create a U.S. will here. It can be created by the U.S. consular agent. So you don't have to go to the United States to make a will with your attorney there. You can do it here, and we can help you construct that document as well. Number 5 is, what does your executor do? Your executor is, after your heirs, the most important participant in your will. Your executor has the duty of making sure that all documentation and all of the will, literally within your testament, is played out and carried out as it's been spoken to or written in your will. So that person needs to organize the documents, so official IDs for the person who's passed away, work with the government to get death certificates, work with the U.S. or Canadian government to get death certificates to send to that country, Other items that they do: communicate with the heirs to organize to make sure that the heirs are engaging in the correct activities to set up so that they can inherit the property from Mexico. Okay, so there are a few moving parts, more than a few moving parts that the executor ends up carrying out. And specific to each case, there's usually a few different moving factors that need to be addressed. So it's a very important person. You certainly want to think about who you use. You definitely want to have somebody who's younger than you. You want to have somebody who understands the Mexican legal system, or at least Mexico to a certain degree. So you want to have somebody who understands the system, is going to be able to work with people in Mexico to finalize and expedite the testamentary succession. Okay, so you really don't want to have somebody who's too busy with their own work at home. That is something that I've seen very often, where a niece or a nephew or a son or a daughter is left and they just work too much to be able to do anything. So you want to have somebody who's going to have enough time to engage in this and carry this out for you in a way that doesn't take too long and doesn't get dragged out too much. Okay. Number 6, what happens if you die intestate in Mexico? Intestate meaning that you don't have a will in place, but you have assets that need for the will to be in place for them to be channeled to heirs. This is a situation that happens more often than I wish. And it is certainly something that we've done at the office. And it's not insurmountable, but it is definitely costly, time consuming, and something that you'd love to avoid if you just make the one move of making the will. So what happens if you die intestate? What we do typically is we take into account what's written in other wills. So if you have wills made in other jurisdictions, those can be utilized as precedent for the carrying out of the intestamentary succession here in Mexico. So if you do have a will, for instance, if you have a will from the United States and it explains exactly who your heirs would be, we can typically replicate that and allow that to play out here in Mexico. But there are many snags and many speed bumps. So again, don't think that this is just something that we can get through very easily. There's a lot of red tape. It's an entire court case. So avoid it, make your will, don't allow this to happen, okay? Number 7, can an executor who is abroad or unavailable designate a power of attorney to have the duty fulfilled by an agent in Mexico? So oftentimes clients will leave an executor who lives in the United States and Canada and Europe, and that person simply, for geographical or work reasons, for whatever reasons, are not able to come to Mexico. That's not a major problem. What can be done there is that individual can visit the most easily accessed Mexican embassy or consulate abroad, and they're in most big cities. So simply go to a big city close to them and have a power of attorney made so that an agent here in Mexico can act upon that, carry out that duty on their behalf. So that power can be bestowed to somebody who's boots on the ground here in Mexico, like me in my office, to carry out that duty. And it's a pretty seamless affair. Here's number 8. What happens if you have a U.S. but no Mexican will? If your Mexican assets are referred to in the U.S. will? Well, that sort of goes back to the question that I answered before a little bit, which is that if you do not have a will in Mexico and you own real property, you are going to have an intestamentary succession situation, which is what you want to avoid, right? That's the big problem here with not having a will. Now, like we said, having a U.S. will or a Canadian will would set legal precedent as to what your wishes were in another jurisdiction, which allows for that to serve in front of the court, in front of the judge, as what your wishes would be interpreted to be if we had to guess or if we had to conjecture as to what to do here in Mexico. Okay, so now, not an ideal situation. Don't think that you can rest assured that everything's going to go easily. So make the Mexican will as well as hold on to the U.S. will that you have. Number 9 is, what will my heirs need to do to receive their inheritance? This is a pretty simple answer. It's not a hard thing to do. The individual, if they live abroad, they have to have a passport. So if you live in the United States, you have to have a valid U.S. passport. The driver's license won't suffice. It has to be a federal document. So the passport's the one. Birth certificate's not going to do it either. They do want the passport. So that's one situation where you absolutely have to have your passport. But obviously, that's not the biggest deal to do, to achieve. So that's that. Now, just like the delegation of the responsibility for the executor duty, the acceptance of inheritance by somebody abroad can also be delegated through power of attorney to an individual who's here in Mexico. So if somebody is in the United States, cannot come, but is due an inheritance in Mexico, they can bestow power of attorney to somebody like me at my office so that I can go act on their behalf to receive and sign for that inheritance and then have those assets channeled, if they're funds, to the bank that's appropriate, or if they're real assets, then achieve the redeeding for whatever amount of equity that individual has in the property that they've inherited. So again, this can all be done through POAs. Nobody has to come to Mexico to do these. Number 10, what tax benefits or implications would there be for my donating property to the UU? If assets were sold and those monies channeled to the UU, would there be capital gains taxes paid on the pre-donation monies? The answer to this is, since the UU is a not-for-profit organization, upon receiving part or a complete inheritance from somebody who passed away here, the UU would not pay taxes on that acquisition. So whether you left the property as is and the UU absorbed it as a property, as a real asset, or if you were to have in the testamentary succession the property sold, liquidated, and those monies channeled as cash, in neither of those instances would the UU pay taxes. Okay. The difference with those two modalities would be that there would be paperwork expenses for the UU if they were to receive the property intact, right? Because there's paperwork and there's notary expenses that are inherent to that transaction. Whereas if they were to simply receive a bank wire, then that's untaxable money that the UU can use, to do good things with. So that's that explanation in a nutshell. Number 11, does the Mexican Testament need to be written in English? The answer to that is yes. Article 2773 of Guanajuato Civil Code states that anybody who's a foreigner who doesn't speak Spanish fluently is supposed to write out their Mexican will in their native language. We've been making wills with clients for years. Some notaries require it to be done. Some do not. When it comes time to execute the will and carry out the testamentary succession, either way that the will was made, it's perfectly fine, and it will be something that can be carried out. The testamentary succession will be perfectly doable with either modality. So it is in the law. It states that they want it that way, but they're malleable when it comes to the time to execute. So don't worry if you have a will that you made that wasn't written out in English. But most of the time they're making you do it now. So it's going to be part of the process no matter what. Number 12, can a Mexican will be made from abroad? Yeah, again, when I mentioned the Mexican embassies and consulates in the United States, Canada, and everywhere else abroad, these offices are able to make you a will. So each office works a little bit independently. It can be a bit frustrating. They're all good offices and they offer all the services basically, but at some of the embassies, they make you provide your own translator, which they don't tell you about. So just heads up, if you do decide to do business, create documents at a Mexican embassy or consulate, make sure that you speak to an agent, make sure that what it is to bring so that you don't have an experience that takes 5 trips and gets very frustrated. So just make sure that you pin down what it is that you want, what it is that they want you to take, and get it done the first time. Because I've seen there be very much variance in the documents that they want you to take from one place to another. So just part of the way things are done, and it's incumbent on you to make sure that you've got the documents right. And obviously, with most things, my office can help out and explain to you what you need to take. But just heads up, things can be done differently in different parts of the country, so be aware of that. Number 13, is there a limit of time that one has to carry out the testamentary succession? The answer to that is no. So a testament can stay open for a long period of time if family and friends cannot get that accomplished. There is no moment where the opportunity ends. There's no statute of limitation, or there's no expiration date upon which nothing can be done. So again, no need to foot drag or create reasons to not do this. I think that being expeditious in the testamentary succession for family and friends is very key to make sure that things don't fall out of orbit and get really, really disorganized. So make sure that you try to get this done as quickly and efficiently as possible, and then you run into fewer problems. You just have so many fewer problems that if you try to get it done quicker than slower. I want to go back to one question here that a lot of people ask me, and it's an interesting aspect in Mexican law, and that is, if you die intestate in Mexico and nobody claims the inheritance, right? If nobody comes forth, what happens to your property in Mexico? The answer to that is that the University of Guanajuato absorbs your property if nobody throws their hat into the ring and nobody is a genuinely legitimate heir. Then the property goes to the state university. And from what I understand, believe it or not, they absorb a lot of wealth. And so it's definitely something that generates, a bolster to their endowment. Now, nothing to be worried about. It's not going to happen as long as you have your will. And if you did die intestate, as long as your family members came forth and they were able to show their claim was legitimate, then this would never happen. But it's one of those aspects of the law that people find curious. Now, our final question, number 14, how can you change a will in Mexico? This is one aspect of the law that's much different from the United States or Canada, which is based in the English common law system, as opposed to what we're based in, which is the Napoleonic Code. That's the origin of our legal system here in Mexico. Most things are logic-based and most things are based on justice, but there are certain things where things deviate, and here's one. In Mexico, you cannot create a codicil, so you cannot change a will, so to speak. It cannot be amended. What you need to do if you decide that information in your Mexican will is obsolete or wrong is that we have to make a new will for you. Now, this isn't a great challenge. It can be done any day of the week, any weekday. So just make sure that you understand that if you were to write something into your Mexican will, there would be no validity to it. You would absolutely need to make a brand new document. And then whichever will is in force in the most current, whichever is the most current will is the one that's in force. And when you pass away, that's the one that is going to be the relevant document that the government's going to take into consideration. So in summary, I really hope that these 14 questions help people understand, give some clarity to the issue of wills, donations, inheritance, and some of the inner moving parts of what that is and what that will be if you die in Mexico with assets. So again, if everything is done in a way that's organized and methodical, you're not going to have problems, even though you're a foreigner. So don't think that everything's going to get jammed up simply because you're from another country. But you don't want to be a cavalier about anything either. So you want to make sure that you have good documents, that you check your documents often, right, to make sure that you don't have information that's irrelevant. Participants in these documents that are no longer with us or no longer in favor. So, just creating the document isn't enough. It's that you make sure that it's a relevant document. And so those would be my initial questions that I think I get a lot from clients, that I think people often have questions about. And we'll obviously expand on this list and get some more. Obviously, your feedback, right, is going to help me be able to create questions that pinpoint what people's questions are, what people are thinking about. So please, this is going to work the best if everybody gives me feedback and asks me questions that are pertinent to issues that, lots of people have. So yeah, would love to keep this going and have this be a conversation. And I think that's it.
So thank you. Thank you very much, Ian. I think that was a tremendous insight into the nuts and bolts within Mexico. There are some questions. You've been answering some on the in the chat box, but I want to go over a few. One question that was asked was, can assets be left to an executor? Can a gift be made to the executor in the will? Or does that violate any laws in Mexico?
Yes, absolutely. So there's no conflict of interest if you have an executor who also participates as an heir. You can have one person be the complete heir and the sole executor. So there's no overlap. There's no conflict there.
Great. A document that's created in Querétaro for advanced medical directors. Is it at this point that is a legally binding document in other states?
So the document that's made here in Guanajuato, all other states that are participants in, or better yet said, that have created an advanced medical directive law for their state, because it's a state by state law, everybody is cross applicable. So if you have one from Guanajuato, Querétaro has its law, so they should respect your document, although it's been made here, which is a different state jurisdiction. But since there should be it should be reciprocal. I'm sorry, I always forget how to say that word.
Reciprocity.
Reciprocity. There you
go. Do you recommend that? How do you convey that information to a hospital or to a medical institution, either in the same state or in a different state?
Right. So
they're coming in an ambulance.
Yeah, that's a great question. So I had a case about 2 years ago where a client was going to have open heart surgery. Okay, so she had plenty of time to anticipate, consult with the doctors and the administration at the hospital. And it was very interesting when she had the conversation with her primary care doctor. She brought up the fact that she had an advanced medical directive made in this state by a notary in the absolutely official way. And the doctor said that document didn't exist. And so we had to show her. It was a very telling situation. So what that made me realize was that it was probably an honest mistake on the doctor's part, but it really is important for you as a patient, if you have a procedure that is going to be scheduled, that you're going to be able to deal with methodically, to be able to talk with your doctor and say, look, these are my wishes. This is the document that I've created. If something falls off the tracks, this is how I want it to be dealt with. And then make sure that there aren't any misunderstandings once you've already been put under, general anesthesia or something like that, where you can't make choices for yourself. So you just want to make sure that the doctor, the hospital, and then anybody else that has a vote in a situation where things got rocky health-wise for you, you want to make sure that all those people are of knowledge and are going to respect the health directive that you have, so that it's not something that somebody pulls out of their sleeve when something went wrong.
Okay. Another question. If we make a donation to a charitable institution, you indicated that it doesn't really matter to the charitable institution how it receives that donation, whether it's cash or whether it's property, except that there's some additional cost to dissolving property. But what about to the individual or the estate of the individual who makes the donation? What is the impact in Mexico of that gift?
So again, as I tried to explain, I think it was a little bit difficult to explain in the short clip, but what I was making reference to was, if you, for instance, let's say that you have a business in Mexico and you have back taxes that you've put off and that you're going to pay over 5 years, okay? So you owe the government X number of pesos for monies that you've generated. Those sorts of taxes that you die with can be offset by the donation of a property or of money to the AC, all right? Now, what it can't do is offset any other expenses that are related to other people who inherit from that estate. In other words, you could give, let's say that you give $100,000 to the UU, right? And you still have $400,000 that you're going to give to your kids and your nephews and nieces. Well, it doesn't affect the rest of those bequests. It doesn't affect anything else within the will that the testamentary succession that's taking place. The way that you gauge how much tax is going to be paid upon an inheritance is based upon whether the heir is a Mexican citizen or a resident of Mexico. So if you are a citizen of Mexico or a resident of Mexico and you inherit property from somebody, whether it be a family member or not, you have much less tax to pay than if you inherit as a tourist, so as a foreigner with just a tourist card. So what we often do with clients is to coach their heirs into setting up the residencies simply to inherit at a much more affordable rate than if they were getting it through them being a tourist. So that's really the linchpin as far as how much is going to be paid at the time of inheritance. So that's really what you need to be aware of.
In your example, where there's a $500,000 estate and $100,000 is given to charity, $400,000 is left. In the U.S., my understanding is that the estate itself has to pay taxes on the size of that estate above a certain amount. Mm-hmm. Does the estate itself in Mexico pay taxes?
No.
So it's just the heirs have to pay taxes on.
Exactly, right. So no matter how big or small, right, in the United States, I think they often talk about that as a death tax, right? And I think that only starts at above something like $2 million.
A lot more than that. Okay,
so it's up there in as far as it's something that's applied simply to very wealthy people. And in Mexico, you don't have that sort of a situation. Each person who is established, each person or organization that's established as an heir, there's going to be a calculation done to see how much tax that person needs to pay upon receiving the inheritance. And so that's what it's based upon.
Okay. Any more questions right now? Bill.
Yes, I have a question which has to do with real property. If you own real property with another, whether you're married or just partners, and you want to leave your share of that real property to the surviving partner or spouse, right, with the proviso that the real property ultimately ends up on the survivor's death with an AC, what are the tax consequences to that? Is there a tax consequence to the joint owner who inherits the entire property upon the death of the other owner? And when the survivor owner dies and the property goes to an AC, are there any tax consequences at that point to anyone?
Okay, that's a good question. So we'll use two different examples, right? You have joint equity in a property, 50-50 with spouse A and spouse B. Spouse A passes away, and then through the will, spouse B absorbs the 50% equity, becomes the sole owner of the property. Okay. So in that case, what we need to do when the testamentary succession gets run for spouse A, who's just passed away, aside from showing the will and the IDs for that individual, we also show the marriage certificate to show that spouse A was married to spouse B, and therefore there's a preferable charge as far as carrying through with you as spouse B absorbing 50% equity that belonged to spouse A. Now, if you have two people who are just individual A and individual B, who might as well be business partners, well, in that sense, you are going to have a different tax situation upon the individual who is individual B inheriting the 50% equity in the building that is the partner, right? So Mexico definitely gives a preferential rate to spouses, but then once the inheritance ends up, so there's one person left. We're talking about the spouses again. We have one person left, and their desire is to leave the entirety of the house or the cash from the proceeds of the sale of the house to the UU. At that point, there is nothing to do with what happened before, which was the testamentary succession where spouse A left to spouse B. That's a chapter closed, and the donation to UU is its own entity.
But I didn't quite understand. If you don't have spouses, but you just have two people living together and they own the property, I don't know, in the States, it would probably be tenants in common or tenants by the entirety. I don't remember that, but, okay. And it automatically passes to the surviving partner. It's not a business arrangement. They own is it tenants in common? I can't remember.
Is that something called a quitclaim? I've heard of something like that. There is something like that in U.S. law, and it's basically an expeditious avenue from that property to end up in the appropriate hands upon the individual who has its dying. In Mexico, there's no quick route, so that's a sort of a shortcut. So no, there is no way for that to take place. That's something that exists through the English common law difference with the Napoleonic Code. So that's something that, again, it's like the codicil. It just doesn't exist in this legal system.
I have another question, unrelated, if it's all right, if I may ask this, sure. Steve. It has to do with the ownership of an automobile. If one party owns an auto in Mexico, a Mexican car, and do you need a will to give that away? What happens with the car?
Yeah.
It's your only asset.
So you can leave the car through the will to an individual who you'd like to receive the car upon your death. But what I always suggest doing is, if you are worried about dying, or you think that it could happen because you have an ailment or something that's pre-existing that could take you out, I suggest
you're all going to go.
Well, sure, but people's probability is higher than others, so it's all a relative situation. So what I suggest people do is they endorse the back of the title to the vehicle. So you can endorse the vehicle. You could say, look, I yield rights to this vehicle too. And then you just leave that in blank. And then you can have somebody sign the name into who you want to be. So it's kind of clumsy to run it through the testamentary succession, because you have to mention this vehicle, and then, writing into the will, since vehicles get used up and crashed, and, you trade them in every 5 or 10 years. I don't really like them being embedded in wills. So the quick, easy way to approach that is to simply have the back endorsed, so that you can move it on to whoever needs to be moved on to in a way that's not so official and so paperworky.
Okay, great. Thank you.
Two things. Helen Marie, you made a comment about the university having 26 properties in San Miguel. What was that about?
Testate situation owned 26 separate properties here in San Miguel, so it happens quite frequently. At that point, they sold them because they were trying to get the money and invest it in one particular place. But that does happen quite a bit. Ian, can I ask another question, Steve? I've got a question in that list. You talk about an AC, but then you used another Spanish term about the organization. Can it just be an AC, or does it have to have the further non-tax designation in order to have the tax, state tax thing work?
Yeah. So Asociación Civil.
AC.
That's right. You're absolutely right. I just said the term in Spanish, but yeah, an AC is going to be an association that is not a profitable organization. It's not an organization for profit. So absolutely. There was, it's interesting you bring that up. There was just a law change, which I'm not exactly sure how it's going to affect things, but the federal government stated that all ACs now have to receive at least 50% of their monies through donations. Okay, so that's going to change. That's going to change the face of things quite a bit. And I'm going to send you some information on that because it's new legislature. But I think it's worthwhile for everybody at the UU and everybody who's in an NGO or involved with any sort of an AC should be aware of this change, because it's going to really affect organizations that produce something, right? So if you produce some sort of a product that gets sold, and that's how you generate your income as an AC, those people are going to be going to have to find a new MO and going to have to be, finding out who to receive donations from. So it's going to, I don't think that with your organization, it's going to jostle things or be a polar shift, because I think that you mostly do depend on donations. I'm not sure of that, but it seems like it would be. But yeah, I'm going to find that new legislature and translate it and send it on to you so that everybody can know what's going on with that.
In this legacy program, are you interested most in real property or in other kinds of property as well?
I'm sorry, I didn't understand that.
As far as the UU goes, we'll take anything we can get.
Yeah.
We prefer cash.
Yeah, right. Because I was concerned about, people who have art and jewelry and all this other kind of thing here, and it looks like an individual inheriting that would have to pay estate taxes on it here. And would they also have to pay taxes to have that taken back across the border into the United States in some way?
So art crosses the border tax-free.
Okay.
So art always crosses the border tax-free as long as you can prove that it's your personal collection, right? That it's not merchandise. So art's free and clear. If you inherit lots of nice items, movable items here in Mexico, and you want to take those things to the United States, is that your question?
Yes. Yeah.
Yeah. So then what you would be looking at is a huge shipping bill, but the United States is not going to charge you for bringing those things in. The only way that the U.S. or Mexico charges you for bringing things in is if they can construe that those things are going to be resold.
I see.
So if it's a business move, but I'm sure that if you were bringing a bunch of household items, art, silverware, things like that, even if it were solid silver, if it were a beautiful set, you could claim that it was your personal items and that it wasn't for sale, and you would be off the hook as far as any taxes.
But you are saying that the inheritor would be charged estate taxes from the lowest level, whatever the value of the estate might be on those things.
On real estate property, yes. But say that in my will, I leave you a house and I leave your friend a beautiful tea service. The tea service isn't going to be taxed. It may be worth $20,000, but there's not going to be any tax on that.
I understand. Great.
Mm-hmm.
Thanks.
Okay. Diego, before I forget, would you please put up Ian's contact information again so that folks can see that? Okay, can you read that? Okay.
Uh,
Are
Here.
there other questions from people at this point? Okay. Thank you. Thank you, Ian, very, very much. Thank you, Diego, for all of your help in both of these sessions. Gary, thank you very much for all you've done throughout this. It wouldn't have been possible without Gary's help. And again, if you want to review the information that's here today or from last week, please, it'll be up on the UU website and on the YouTube channel. So you're encouraged to take a look there. If anyone needs to reach me through the fellowship, that you can do on the endowment tab through the UU website as well. And I thank you all for attending. I think this was very, very informative. And I wish you all well, and long health to all of us. But when it's time, hopefully you can do good with your estate or with whatever your belongings are. You can do good as well as show your loved ones how much you love them. So thank you very much for everyone for attending.